Just to sum up so we don't lose track, what I said, I want to approach this from a sort of broad concept rather than looking at all of the details. One of the problems that society has had to deal with right from the very beginning is that if you have an unalienable right, if you have a right nobody gives you, you get endowed with it, like life, liberty, allows you to work. When you work, you can acquire property, so property would be there. Then there will always be a tendency of somebody to take that from you, and so how do we protect that? And through history, what happens, institutions arise, and they are quite effective for a while, and then society changes, and those cease to be as effective, and then new institutions arise from that. Bearing in mind that anybody who's able to protect you is just as able to kill you. So whatever system you put into place to protect you, you need to have an institution which actually protects you from the person who's supposed to protect you. So history developed, and the last, and very successfully, as I say, if you look at history, I think that most of these problems have been largely solved. And the last problem we got is the realization that actually Parliament can attack you. So in a place of the sovereignty of Parliament, limit Parliament through a constitution, and the very purpose of the constitution then is to protect life, liberty and property. That's the basis of the American experiment as set out in the Declaration of Independence. Now, if that was the case, then if we want to go and put a provision in the constitution which is going to attack the rights you're trying to protect, then you can understand it's almost impossible to achieve that. You can't achieve that without having a contradiction within the Constitution itself. So you'd have to have a provision in the Constitution which is unconstitutional. To use Stephen's example, if you decided you want to kill blue-eyed babies, you'd have a provision in the Constitution, which we've got, you have the right to life. Then, in order to kill blue-eyed babies, you'd have to put in another provision which allows you to kill babies. So how are you going to reconcile those two provisions? They are irreconcilable because the Constitution was only designed for the first protection of life, including blue-eyed babies. So to achieve what you want to achieve, and that is to violate the fundamental principles of the Constitution in a Constitution, then will be just about impossible and will result in contradictions, which you're going to do. So the question which we now have to ask is, if the government wants to go ahead, which it's planning to do, to amend the Constitution to allow what the Constitution will not allow it to do, what are the problems that we are going to encounter? Okay, now, there's two questions at this stage, two simple questions. You will end up with the contradiction anyhow, but you have a procedure, and the procedure is we want to do this anyhow. What procedure are you going to follow? And as I will indicate, when you do follow that, you still will not get rid of the contradiction. So the two questions, and the first question has got sub-questions, and anybody who knows the Constitution will know why this question is asked and why it's got sub-question. Is expropriation without compensation a violation of the rule of law? Is it a violation of human rights? And is it racist? Now, if it's any one of those or all three of those, then it falls foul of Section 1 of the Constitution. So if you're going to put that into the Constitution, then you have a contradiction, because Section 1 will say you can't do that, and then you're going to say, I've done it. So I have a right to life in the Constitution, I'm killing blue-eyed babies. Can't do it. Simply one of those don't fit. So you'd have to decide how you're going to reconcile it. And you may try through interpreting the contract or Constitution or something, but the contradiction is there. But it still means, for our purposes, just to get it clear, is it a violation any of those things? Rule of law, human right, and is it racist? And as we know, our Constitution has got two ways of amending it. One requires a higher percentage, 75%, and the other one a lower percentage. So if you're going to put this into the Constitution, and it is a violation of one of those three, do you need 75% of the vote? Because I think now it's quite clear that the government is not looking at that at all. They're going to look at just getting the normal requirement to get to the votes, which means if they don't get the 75%, then you have a further constitutional problem, that the introduction of the amendment didn't meet constitutional muster to get into the Constitution in the same time. But in any event, you're still going to have a violation of one of those three provisions which we got. Okay, now, this is a commonly held perception about constitutional health, particularly by lawyers, and that I've already referred to, is if you want to do something and the Constitution doesn't allow you to do it, then all you have to do is amend the Constitution. It will then allow you to do it. So if you want to kill blue-eyed babies, you can do it, but you must put it in the Constitution. Now, I don't think that is correct, but that would have a look at it. So expropriation with compensation is limited only by the existence of Section 25. Now, from the discussion we had this morning, which is an important discussion from Andrew Jeffries, there are views that you can expropriate without amending the Constitution. Now, the government obviously doesn't hold that view because it has indicated and has issued the 18th Amendment to the Constitution that we have to amend the Constitution. Otherwise, it could have gone the Andrew Jeffries route and simply say we can achieve what we want to achieve without amending the Constitution. And in fact, I think the best option would be to do that because Section 25 has got provisions to correct the injustice of the past, so everything's been catered for the best you can in terms of the existing view. But so the view that is so often encountered that all you have to do is amend the Constitution to achieve that. Okay, everything is allowed, provided it is not in conflict with the words of the Constitution, and that means the democratic majority gets the majority legislatively. So if you have a democratic situation like South Africa, democracy rule, and you say that there is no limit at all because we've got the majority, all we do is change, put in the Constitution, we get it. Under those circumstances, it's clear the Constitution achieves no purpose at all. So babies can't be protected because you've got the majority and the majority will do it. The other alternative, no, you can never kill blue-eyed babies, even if you wanted to, even if you put in the Constitution, you will not be able to chew it. So those who hold that view would say that, if property is protected, then I must find that protection in the Constitution. I must find in the Constitution where it says property is protected. So in the example of the blue-eyed babies, you could murder them if it's in the Constitution. And there's a negative view, which is also encountered, is if blue-eyed babies are to be protected, then you have to show me where in the Constitution they are protected. So if property is to be protected, then you must show me in the Constitution where they are to be protected, because if it's not in the Constitution does not protect them. In reality, blue-eyed babies are protected because it's an inalienable right owned to property, and so that those rights exist outside of the Constitution. Very clear in the American situation. They had long debates about this, and you can read them for yourself if you want to. Okay. So this is the amendment, which is the important part of the current amendment. It's really done what most of the legislation since 1994 has done. It's very confusing and never clear what it says. So the provisions in bold are the additions to the Constitution. So this is, if it does not get amended before it goes to Parliament, this is what is going to be put before Parliament. But I suspect it's going to be amended because this doesn't really help anybody at all. So I think all you need to look at well, let's read the whole section and just concentrate on the bold part which you've got. Subject to compensation, the amount which, the not bold part is what's already there. Subject to compensation, the amount which, and the time and the manner of payment which should either be agreed to by the parties, decided or approved by the court. So that's a provision which say you would have to pay compensation. And then the bold part is where you don't have to pay compensation. Provided in accordance with Section 3A, which is below, the court may, where land or improvements thereon are expropriation for purposes of land reform, determine the amount is nil. So the Constitution has now got a provision in which says you can pay no compensation at all. So whichever way you want to look at it, whether you say a court will make that decision or somebody else will make it, you have the problem. I have an asset which has got a value and I'm going to get nothing for it. My natural right to own the property has been violated. Now, we don't know what that will be, because it means there has to be another Act of Parliament. Until we see that, we don't know what that means, which is in Section 3A. National legislation must, subject to Subsection 2 and 3, set out specific circumstances where the court may determine that the amount of compensation is nil. So, in terms of the Constitution now, you can expropriate property with a zero value, and the court will then rubber stamp that but we don't know under what circumstances, because that will be determined in terms of national legislation, which has still not been put before. So that separate national legislation is then also subject to constitutional challenge, which we've got. So I think that it should be clear that the proposed amendment to the Constitution results in expropriation without compensation. And that's the thing. It's to take an unalienable right from a person, which is what 2,000 years of constitutional development has been aimed at avoiding. So just keep that in mind, and then let's have a look at Section 1 of the Constitution, and then we have to determine whether the amendment to take property without compensation, whether it runs foul of Section 1. If it does run foul of Section 1, then we have to ask ourselves what do we need to do about it. One could argue that it's inconsistent with Section 1, so you either can't pass it or you must get rid of Section 1. Or you can say, no, it can be there, providing you get 75% of the vote. Then it is there, and we have a contradiction in the Constitution, which you have to try and sort out or live with that afterwards. So this is a simple matter. The Republic of South Africa is one sovereign democratic state founded on the following value: human dignity, achievement of equality, and the advancement of human rights. So you can't violate human rights with the amendment, because then you are violating Section 1A of the Constitution. It can be can't be racist. So if you put in there you can only take white property, then you could attack it on being racist. It doesn't say that. So one can argue it doesn't run foul of Section B. It's not a racist provision. But when you start implementing it, you can then have challenges at court. It's been implemented as a racist institution, and therefore it is it is void in terms of Section 1 of the Constitution. And then the Constitution itself is based on the rule of law. So does it violate the rule of law? If it does, then you've got the same position as the human rights. Now, these are additive, so if you violated any one of them, it's enough to bring it under Section 1. If you violated all of them, that's just 3 times under Section 1, which you got. Okay, thus, if expropriation is a violation of a basic human right, or if it is racist, or it violates the rule of law, it would be in breach of Section 1. So what does that mean? Section 1 would have to be amended to remove it. In other words, you could say, let's get rid of Section 1. We don't need Section 1. I think the South African Constitution, as far as I know, is the only constitution in the world that actually puts the word rule of law into it. You know, there's other constitutions it's implied. And I think in the UK, only one act of parliament in the more recent years have they actually introduced the rule of law. So you could say, well, Section 1 was a mistake. It's too restrictive. Let's get rid of Section 1. But that's not the proposal. So the 18th Amendment isn't asking to amend Section 1. So Section 1 is still there. So you have to ask yourself, well, can we have Section 1 and also a violation of Section 1? So I would argue that since expropriation without compensation, if it's a violation of any of those provisions, is then contrary to Section 1, and therefore, in essence, by putting in the expropriation, you are now going to violate Section 1. And at worst case, you can only do that if you get a 75% vote. So you'd have to get expropriation without compensation passed with a 75% vote. Then you're still going to have the contradiction of the term. So the amendment is passed with 75. It can consume this section, will violate. Then, of course, the court's going to have a problem. What do they do with the 2 sections which are in conflict with each other? We can look at that a bit later. So if Section 1 is not abolished, it's left in time, then it's an interesting concept of the Constitution itself, which becomes unconstitutional, or a provision in the Constitution which becomes unconstitutional. Now you can say we can solve that by interpretation. You can say that, you know, there's a rule of interpretation in contracts that the specific always overrides the general. And since you've got a specific provision in Parliament actually understood that, and therefore you can say that that Section 1 can exist there simply by interpretation. That doesn't really help, because you could say, let's put the blue-eyed babies in there. You can say, put the blue-eyed babies in, that's a specific one, it overrides the right to life, and therefore that's valid. The entire world will know that murdering blue-eyed babies simply is not allowed, it simply can't fit into the Constitution under those things. So the Constitutional Court would have a problem over there. Secondly, Section 2 of the Constitution. This Constitution is the supreme law of the public. Any law or conduct which is inconsistent with it is invalid, and the obligation must be fulfilled. The obligations of the Section 1 must be fulfilled, and therefore any law, and one can argue that law would also include the Constitution, so even the Constitution itself has to be valid under those circumstances. So you might have to get rid of Section 2 of the Constitution. Well, but in any event, as we've seen, this amendment also says that in order to understand it, we're going to have to get another piece of legislation. So that other piece of legislation will spell out under what circumstances you can get zero or null payment. One can argue, okay, that piece of legislation will never meet the requirement of Section 1, and so when you try to pass the second one, that's going to be unconstitutional anyhow. And it violates the entire structure of the Constitution, because now we have a Section 2 which says you are obliged to uphold the Constitution, and now you say we're not going to uphold this one. So you can see the problem which I have, which I've told you earlier on. The Constitution was designed to protect fundamental rights, and it's almost impossible to put something in which violates it, because it's designed that that doesn't happen. So you can't put something in that doesn't work. So it is, to me, a major problem. Okay. Implications of removing the offensive phrases. You can amend Section 1 to remove Section 1 itself, or remove human rights, remove non-racism, and you remove the rule of law. That actually will make no difference. It may make lawyers happy, but the action will still be contrary to all three of those. And so if you pass those laws, as a matter of fact, it's a violation of human rights. As a matter of fact, it's a violation of the rule of law, which is an international concept. It's not a local concept which exists because of our Constitution. So you really don't achieve anything other than to get rid of a constitutional problem, but you don't get rid of the actual problem of having something which is contrary to the basic human rights. It's also contrary to the rule of law, and also doesn't have a constitution which upholds it. So under those circumstances, the Constitution loses a lot of its credibility and legitimacy. So we end up with having an idea this is a banana republic with a banana republic constitution. It doesn't really help us. Okay. I think I have missed one slide, so I think I must get to the last slide and come back, or I've put them in the wrong order. So what this slide should be before the conclusion slide, so I will go back. So the question which we have to, in fact, I'm missing quite a few slides. Yeah, okay, that's good. I got confused with my projector here. It shows one last slide. There's other slides behind it. Okay, so we can go back and do it in the right order. I thought we lost one. Conclusion. It does not matter which way one looks at it. The requirement of Section 1 must first be addressed before amending Section 22 is addressed. That doesn't look like it's happening. In other words, the processes which we have in mind is just ignoring Section 1, and so it's not going to happen. I argue that Section 1 cannot simply be ignored. Section 1 can be amended or repeated in its entirety. That would require 75%. Section 25, which is amendment, in any event would require 75%. It does not matter. The Seventh Constitutional Court may, I think the confidence in the Constitutional Court is decreasing as time progresses, so the Constitutional Court may simply to ignore that in the light of public opinion, and that means the Constitutional Court in South Africa internationally will lose credibility. So we all know that this is a violation of Section 1. We all know this is a violation of unalienable rights. It shouldn't be, and you choose to ignore it. And you say, well, then the Constitutional Court, as an instrument of upholding the Constitution, loses credibility. Okay, a lot of this now hinges on the issue of whether it is a violation of human rights, whether it is a violation of the rule of law. So let's have a look at it. What is human rights? Human rights is equal to first generation rights plus second generation rights. Second generation rights are sometimes referred to as economic rights. And so there is like a tendency to think that the socialist rights have replaced the first generation rights. They have not. They added to it. So there are additional human rights. And the first generation rights are the unalienable rights, the rights to life, liberty and property. So they have not been removed. They've added additional rights onto it, which are the economic rights under there. And so the economic rights are really socialist rights, the rights to the free lunch. Now, the existence of these second generation rights, socialist rights, they obviously violate the first generation right, but nobody bothers about it, but they're violated at the tax level. So you're providing people with more free lunches. The free lunches have to be paid by somebody, and they get paid by the taxpayers who pay it. And so one can argue the second generations impose a cost. And so there is a cost, but they don't take away the rights which you've got. They don't take away the right to property, but they do mean that you end up paying greater taxes. So expropriation without compensation is a direct violation of the first generation of human rights. So expropriation without compensation is a violation of human rights, is a violation of Section 1, and therefore Section 1 is violated, as I have explained. So expropriation would require to either amend that Section 1, or it would require at least 75% vote on the amendment, so that you could say, okay, we understand violating Section 1, but the Constitution allows us to violate Section 1, if you like, providing we get 75% vote. So you're going to have to get the 75% to pass the expropriation without without compensation. But what about the rule of law? Okay, now I want to introduce you to what's my favorite definition of the rule of law, and that comes from Rex. I have told him a dozen times that this is a fantastic, we could have a separate paper to explain why this definition is actually right. It's a fantastic, anybody who's tried to study the idea of the rule of law, you'll know there's no definition of it. You know, there are books written about it, but if you try to find what is the definition, you don't find it. And Rex now has provided a definition which is really quite fantastic. The last person who tried to, last person who authoritatively tried to tell us what the rule of rights is, Mr. Chief Justice Tom Brigham, who was Chief Justice of England. And he was invited to go and deliver a lecture at Cambridge University, and he thought he'll pick an easy topic because he said, you know, lawyers are used to dealing with problems which are given to them. They are not used to making up their own problems. So I have asked to go and deliver a lecture. I don't know how to deliver the lecture because this isn't a problem that somebody sent to me, so I have to think it out for myself. And so he said, I thought what I'll do is I'll pick something simple, like the rule of law. And then when he started to work on it, he said, I realized that actually it has no meaning. So when he was finished, he wrote an entire book, a small book, but wrote an entire book. And so there's a book if you want to know what the rule of law is, but you can read it, there's no definition. So Rex has done a better job than that. And I think this definition is really spot on. I have incidentally found that a very careful reading of the greatest constitutional lawyer, which is Dicey. You get the same definition in Dicey, but it's not as a definition. He's discussing it, and there you find it in. So fantastic definition. Okay. The rule of law is the barrier the law sets against tyranny. Rex didn't tell us what tyranny is, but there's a fantastic legal tradition which seems to be forgotten, and that is lawyers should not talk about definitions. Lawyers must use words descriptively so that they explain themselves. So if everything has to be done in terms of a definition, then you're going to have a problem. But we're saved by this because John Locke explained what tyranny is, and that's quite useful. Tyranny is when you act outside of the rule of law. So it just turns out it fits very nicely with Rex's definition. So the idea is very, very clear. The government wants to take your property. Can it do that? There is a barrier which stands in between you and the government, which is the law. And in this case, it's the Constitution. Because if you want to take the property, it's a violation of first-generation rights which are enshrined in Section 1 of the Constitution. So to come take your property is to violate your first-generation laws, and therefore is to violate the rule of law, because the Constitution stands in the way of the government doing it. So they would have to violate their own constitutional requirement. So it violates two of those provisions in Section 1 of the Constitution. The Constitution recognizes first generation rights. The Constitution recognizes property rights are protected by law. Therefore, to allow expropriation without compensations violates the duty to protect first generation lines, which is Section 2 of the Constitution. It is a violation of Section 1 of the Constitution, which requires a 75% vote. The amendment does not introduce a law. It simply grants a discretion to court and parliament. If you go back and think and reread it, you'll see it actually doesn't grant a law. It says the judge may allow it and parliament may pass a law. So all it does is give the judiciary and parliament a discretion. The discretion itself is a violation of the rule of law. The rule of law requires that the law rules and that you can't appoint people to simply exercise a discretion. So the very amendment is a violation of the rule of law. So the amendment as it now stands violates the barrier of the law and therefore violates the rule of law itself. Is it racist? As it stands, it's not racist, but what will happen is that when apply the law, all allegations will be as being applied racistly. And so at a lower level in the courts, the question of racism would then arise and should be opposed. And it will be opposed on a case-by-case basis as violating Section 1 as being racist. And if that's the case, then the application to that particular court case becomes null and void. So where does this leave us in practical terms? You understand that my approach is really to take a broader view than a detailed view. It's going to make life very complicated. You know, this is not going to solve anything at all. It's going to be very expensive to operate because every step of the way could result in litigation, could add years on it. And if you study the Zimbabwean position, you'll see that the Zimbabweans try to do something very similar and then eventually abandon it to say, look, this is too complicated, it simply does not work. And so the amendment, even if it gets passed, simply will not work, being there. Okay, so the conclusion, the truth of the matter, the Constitution was designed to uphold the rule of law, to uphold the first and second generation rights, to operate as a non-racist society, to uphold the rule of law. It's now trying to do everything it was designed not to do. Don't have to be a legal genius to know it cannot be achieved. So expropriation without compensation simply does not fit, and it cannot be made to fit. So it's going to be a disaster. Now, I've gone to a bit of effort to try and explain why this simply is legally not and historically is not possible. It does beg a simple question, an interesting question, which I find quite amusing when I worked out the answer to the question is, why do it? The ANC negotiated a contract to protect fundamental rights. Now, why 25 years do we go and then try to put in something which violates the very rights it wants to put in? You put in a constitution and then violate the very constitution you put in. The same body, the same number of people. There is an answer to it. It is quite an amusing answer when I think of it. So there's a further truth. How do we explain this great contradiction? A party in power is not the same as a party which desires into power. So when they drafted the original constitution, they wanted to get into power. They are now in power. And here you get the solution which was given by Jean-Jacques Rousseau. He says, no one fights for oppression. They all fight to become the oppressor. So when they drafted, they were fighting to get into power. They're now in power. So now what they want to do is to use the constitution which they put in there to be able to oppress people, but the constitution was designed to achieve exactly the opposite. So even if you manage to make these things, you're still going to have a constitution which is in conflict with itself. Thanks a lot.
Well, I'm going to start off by asking you a couple of challenging questions.
Okay.
Because they are the kinds of questions that I'd be faced with while presenting your arguments to a court. So first of all, there is a difference between that which is legal and that which is moral. Now, you kind of have two big schools of thought to this. So there are positivists who say that the law is found in our sources, so our legislation, our common law, our constitutions. And then you have natural lawyers who say, well, if the law is immoral, it is not a law. So I want to use the example that you give of introducing a law which says that you can murder blue-eyed babies. Now let's imagine that a new society gets formed and they produce legislation that says if any blue-eyed baby is born, the police are authorized to go and murder that baby. And a blue-eyed baby is born and the police go out and they do that. And no court convicts them of murder. Have they done anything immoral? I say yes, obviously so. Have they done anything illegal? They realize the road. No. They have obeyed a law, it's just an immoral law. And so the difficulty in the presentation is this equivocation around rights. On the one hand, there are the rights that we have in law, on the other hand, there are the moral rights. And I think everyone in the room is going to agree that when you confiscate someone's property and pay them nothing for it, you have done something deeply immoral. The question is whether it is also illegal, and whether in principle it must always be illegal. In other words, that right is so embedded in any possible legal framework that you cannot do it. So how do you respond to those sorts of critiques that you might do something immoral, but if you change the Constitution sufficiently, it's no longer illegal?
No, it's quite simple, because I'm not having a moral argument, I'm having a purely legal argument. So the question is, are you violating the Constitution? So take the blue-eyed baby situation. We have a Constitution that says you have a right to life, but you have a provision in the Constitution that says you can put blue-eyed babies to death. Now, those are in direct contradiction with each other. And you have a provision which is the founding basis of it, provision 1, which says that you may not violate human rights, and you have provision 2, which says that you must uphold section 1. So now the legal position is really quite simple. The provision you've just inserted into the Constitution which says you must put blue-eyed babies to death, that is void. This goes back to Coke all the time. You know, is this a void provision? So when the police come and say, we are now going to go and kill a blue-eyed baby, you say, sorry, we're going to get a court order. Now, if you have a constitutional court that's functioning, not a moral argument, a legal argument. Has it violated the basis of the Constitution? The court would have to say yes. So the Constitution becomes void. So it's a debate I haven't entered in, which I'll leave Martin and others to enter into this. Is, can the Constitution itself have an unconstitutional provision? Now, is it absolute? You know, I haven't argued on that point, because there are sections in Section 25 already which allows you to deal with the past. So are those sections adequate? Nobody's argued they are not. What we're saying is we want to put some more onto it. So we can say, yes, the moral argument as to whether we can redress the past is already in the Constitution. So this is not a moral argument. It's simply saying you want to take an action which is in violation of Section 1, Section 2, through a provision which is in the Constitution, and that provision is contrary to 1 and 2, therefore we declare that to be void. So you can't put blue-eyed babies to be, and you cannot confiscate property without compensation. If you say, I want to redress the past, then we can say, let's have that debate, but let's have it in terms of the current provisions which we've got, because we haven't argued whether those provisions are unconstitutional. So I haven't put this is not a moral argument, this is a purely legal argument. And so it comes back whether what you're trying to do violates Section 1 or not. If it violates Section 1, then you're bound by Section 2 to rule the law which violates it to be unconstitutional. So the best option you've got, if this passes without the 75, then the best option you're going to have is to say, we've effectively, which is really the basic structured argument, we've effectively amended the basic structure of this contract by putting in this provision, but we did it with 75% of the vote. You say, I didn't get 75%. Then you say, well, sorry, your blue-eyed babies have to be protected by the law, because for 2,500 years we've worked out how to solve it, and we solved it in America in 1776 with a constitution. And now we have a constitution which has a provision which is completely contrary to that. Okay, that provision goes out. That's why I said I have great difficulty to understand how you are going to amend a constitution designed to achieve something by putting something in which doesn't achieve it. So it's not, I haven't put a moral argument for it, I put a legal argument for it. Now, I mean, the argument you might want to put in is that I don't think that taking property is a violation of human rights. Now, the Marxists might say no, they don't. Tom Bingham, is that taking property is a violation of first-generation rights? It's a violation of human rights. So I think the legal authority would be against the argument that taking property is not a violation of human rights. Once you get that, then it's a violation of human rights. It's also a violation of rule of law, because the Constitution would uphold the human rights, also a violation of Section 2. It's a purely legal argument. The rest of it wasn't a legal argument. As I said, what I like to do is to get the concepts clear in my head and then deal with the nitty-gritties of the argument. This is closer to the nitty-gritty.
Two questions. I had to pop out for a moment. I do apologize if this is a silly question. Martin's basic structure doctrine has some judicial endorsement in case law. Does this interpretation of the rule of law, or this approach to the rule of law, have so far in South African case law any endorsement?
It's a good question which I can't answer, because if you take the approach which I have adopted to this point, it's really to first get the principles, and once I've got the principles nailed down, then I can look at the further argument. I think there's a better way to ask the same question you got, and that is, the Americans actually tried to go back on this and uphold the fundamentals. In the paper, I end up with something which I have not discussed, and that is, I started off saying whichever system you put in, there's a danger somebody else is going to subvert it. And the last paragraph I put, penultimate paragraph, I think, I said that at the moment constitutionalism is being subverted. So the fundamental and yet claimed principles have been now subverted. So the Americans themselves may join an argument to say, we don't agree with that. We don't think that fundamental rights are protected. We think it does a whole lot of other things, but not that. And since 1776, we've never tried to do that. So unfortunately, I can't answer your question. If we come back next year, then we'll have part 2 of the paper. But at this point, I just wanted to get the principles clear in my head.
And then as a principle-based question, let's say we go to court with that argument, we go to the Constitutional Court, and we lose. What would be the implications of the Constitutional Court rejecting your reasoning of the rule of law?
Yeah, that's a question I can answer, but it's one I've tried not to answer, because I don't think people will like the answer which I give. But there is an answer to that. And that is that constitutional principles have always been upheld by force. So if you get to the position which happened in the Civil War, happened in England, where it says we are not going to uphold your now, if you want the most tragic example that I can think of, it's happened in Rwanda, is the United Nations realized that everybody's going to be slaughtered, and then the general gets into the helicopter, who incidentally afterwards suffered a nervous breakdown. So this had an enormous impact on his own life, and he didn't have much hope on it. As he got onto the helicopter, he said, the only thing I can tell you now to do is go and defend yourself. So if your fundamental rights are going to be violated, and the institutions which we have will not protect those rights, then you have to think of ways of defending yourself. Otherwise, what you're going to have, everything you've got taken, your lives taken. So at the fundamental, it's a point I have made in the paper, but I haven't emphasized it too much in the conclusion. In the end, if you cannot defend your rights by force, you have no rights, and that's a big problem. The gentlemanly way and the civilized way is to do it through institutions, but if those institutions fail, then there's a major problem. I don't know what the answer is to that. In Rwanda, incidentally, the Rwandan people who were being slaughtered had their own army. They were not saved by the international armies. They were not saved by anybody except their own army, which came to their rescue. It was out of the country, but it did come. If they didn't have an army, the rest of them would have been slaughtered, and the world would have done nothing, despite the fact that there is a genocide treaty which says all countries are supposed to intervene. None of them would have intervened. If you read the history of that, they did everything in their word to avoid the word genocide, because the moment you mentioned that word, they would be bound by the treaty. So the question you ask is a good question. What happens if your rights are violated and the institutions which you put in place to protect them will not protect them? Then there's a problem, and I don't know that there's a solution to that problem. But in the end, it can't be a purely intellectual argument. And the Americans are going to have to face this sooner or later as well, because my sixth, which is quite a big, they are running into this problem, and I'm not sure they have understood it or confronted it. Okay, sorry about that. No more easy questions. Okay, thanks a lot. I think I've taken too long now.